I'll just go ahead and advise everybody, we will be muting everyone's microphone. If you do, just like all other meetings, if you have a question or comment, please use the raise hand button that you'll find down on your participants tab. And you will be unmuted and be asked to address, or you can raise your point at that moment. When we vote on something, if you would please use the yes or no buttons also in the participants tab. That's how we will be counting votes for today on any action items. So with that said, Peter, I believe we are up and running on YouTube.
Yes, we are live on YouTube.
Great, thank you. All right, Mr. Chair, I think we're ready to proceed.
All right. Thank you, everyone, and thank you to those folks who are joining us today on YouTube, and obviously thanks to all of our members of the Ethics Committee, and also I see a lot of guests. Grievance is not meeting this morning, having already finished their work for the day, which will be an admonishment to ethics to move along. But we have a lot of visitors today, other counselors who are joining us, and I'm sure we'll have other folks who are joining in. First thing I want to tell everybody is thank you all for joining us today. I hope that all of you are staying safe and well. So far as I know, there's no counselors or staff folks that I'm aware of have been diagnosed or come down with COVID, but I know that affects everyone's life, some more personally than others through extended family or friends, relations. We're all affected by that, and I hope that you're all doing your best to stay safe. And I wish you all continued good health and hopefully good luck in managing as we move forward. Members of the committee and of the council are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest in the appearance of conflicts, and are instructed to refrain from participating in any matter that comes before this committee with respect to which there is a conflict of interest or the appearance of such a conflict. If you are aware of a conflict at this point, please let us know, or you may tell us that as we move on down the agenda when this particular item comes up. But if you'll let us know of that, we'll certainly make a note and excuse you from participating in that endeavor. I also want to thank all of you, members of the committee and members of the council and the public who participated in our special meeting a couple of weeks ago. I think that was very informative, hope so, and helpful to the committee as it moves forward with its work today. Folks, we have a very full agenda. I'm going to have Brian again, although he just did the ground rules a moment ago. Some of you may have joined since that time. And Brian, if you would remind folks how sort of the meeting will work with respect to the remote situation that we're in terms of getting our attention, voting, and those kind of things.
Certainly. Thank you, Mr. Chair. So everyone who is on the call, you have under your participants tab on this Zoom call, you have the ability to raise your hand. If you want to offer a comment or a question, please click the raise hand button. We will otherwise be muting all the participants and we'll be monitoring that function. So if you raise your hand, then we'll pause and unmute you. But just for clarity and for everybody being able to participate in a way that we don't end up talking over each other, we will be muting everybody until you're called upon to offer your comment or your suggestion. As far as any votes are concerned, under your participants tab as well, you have yes or no buttons. Please vote yes if you are in favor of a motion, and no if you are opposed to the motion. So that's how we will conduct this particular meeting. But in the meantime, if you do get kicked off or anything like that, please just click the link again. You will be able to join back in, and you can always shoot me an email if you're having technical difficulties. With that said, I think we're good to go. Do you want me to move to the first item on the agenda?
Yeah, folks, we'll start and move our way down the agenda. Roman numeral 1, special agenda items. Number 1, administrative matters, report on trust account audits. Brian?
Yes, that's going to be me. Anne wasn't able to join us this morning. So you have her audit report in your materials. The audit report covers the first 2 quarters of the year because, of course, you know, we did not meet in April. The audits have transitioned from in-person to remote due to the health concerns with COVID-19. But with that said, Anne covered districts 9 and 17 in the first quarter, and then districts 4 and 43 In the second quarter, District 9 was last audited in 2012. 17 was last audited in 2014, 4 was audited in 2015, and 43 was last audited in 2016. 17 total audits were conducted in District 9. 26 different audits were conducted in District 17. 28 audits were conducted in District 4, and 19 audits were conducted in District 43. The two most common rule violations that Ann noted during these audits, 22% failed to identify the client and the source of funds on a particular disbursement or deposit when the source was not the client on that original deposit slip. And 20% failed to perform quarterly transaction reviews. So I think that's kind of a thing that we typically see from these random audits. But if I do say so, I think that percentage number is actually a little down. So perhaps that's a good job there. Audits for the next quarter will be in District 5, which is composed of Duplin, Jones, Onslow, and Sampson counties, and District 7, composed of Bertie, Halifax, Hertford, and Northampton counties. And that is the audit report.
Thank you, Brian. Any questions about that? All right. The second item is report on ethics phone calls from the prior quarter. It's actually, I guess it would be 2 quarters. So Suzanne, tell us about how busy y'all have been with ethics inquiries.
Yeah, I had to combine the numbers for the past 2 quarters because we did not have access to the database for a while, and we had to go back and re-enter some of the inquiries. But for both quarters, we had 2,250 inquiries. So if you wanted to look at that, the average for the two was 1,125, which is pretty much on par with where we have always been. So we really did not slow down at all.
I guess that's good. I'm glad to know that our members are still making their usual inquiries. Again, another service that we offer to members, and remind all of the counselors to remind their members that that's an easy way to access the ethics department at the State Bar. If you have questions or concerns about issues, to place a call to Nicole or Suzanne, or send an email to either one of them, and they'll be happy to try to assist you with with that kind of an inquiry. The next item is report on CLE presentations for the prior quarter. Brian?
Sure. So the CLE presentations, we have been continuing to present CLEs. You have in your materials a list of, I guess there are 9 different presentations that I made over the past 2 quarters. We are still available though, and I guess this is really not just for counselors, but anybody who's watching on YouTube. If you have CLE needs, you need a speaker, we can present via Zoom or WebEx or what have you, but we are still in the business of and ready and willing to assist lawyers as far as getting those continuing legal education credits, particularly those ethics hours. So we had, like I said, we have a number that are in your materials, and I believe there's some here that I know Nicole was engaged in some presentations as well. But again, the message still stands. We are ready and willing to help with obtaining those CLE credits and those ethics hours if anybody has a need.
Thank you, Brian. Next item is rule amendments, the information report on the committee to study advertising rules. As you recall, last quarter, the Committee on Advertising sent around its report, a lengthy report, to all of the council for comment. We got a couple of comments back. I appreciate the comments from a number of counselors that congratulated the committee. This has been a very hardworking committee. It's not an ethics committee. It's a committee composed of a number of different counselors from all over the council. Has been a very hardworking committee and has put together a really great product. Brian deserves a lot of credit for having herded the cats that are on that committee into producing a product that I think we can be proud of. David Johnson from the Office of Counsel had a couple of what I would call technical sort of corrections that we did make. The committee approved those corrections. Brian, you want to just highlight where we are in that regard, please?
Certainly. So the earlier this month, the committee that was appointed to study these advertising amendments approved the. Oh, excuse me. I think they're on mute somebody real quick. the committee met and approved the final report after we, as David said, just reviewed any comments and made some corrections. That report is now heading to the executive committee. The executive committee will vote on that today. The recommendation from the committee, from the Advertising Amendments Committee, is to publish all of the proposed advertising rule amendments to the profession over the following quarter. So you will find the final report on EDDS. We're also going to publish that on the website, presuming that these advertising amendments are voted for publication. But over this next quarter, I would encourage you all, again, if you have not looked at them, take a look at them again, or even if you did look at them before, look at them again and see if there's anything that strikes you. Encourage the members of your different districts or just your professional circles to take a look at these, because there are some I think hopefully good changes, but there are some substantial changes to the advertising rules, and we welcome all feedback on these amendments. So again, that's currently posted on EDDS, and presuming that it is voted for publication by the executive committee and subsequently by the council tomorrow, they'll be published on the website.
And the way this is being handled, folks, just like anything else that would be done, would be sent, that the council approves it, the executive committee approves it, sent it to the council, and the council approves it. It would be out for publication to the profession and the public for until the next meeting, and then that committee, the advertising committee, would process any comments we get, make any recommendations then, and then it would go. Ultimately, would go, if it's approved, would go to the Supreme Court for rule adoption. That's sort of how the process works. Any questions or comments from anyone on the meeting about the advertising committee's work? Okay, and I'm relying on Brian or Peter to let me know if anyone does raise their hand. If you have comments, as Brian said, comments, questions, please use the buttons on your Zoom meeting to let us know, and we'll be happy to try to take any questions or comments that folks have as we move along. The next item is a proposal for an amendment to the preamble of the North Carolina Rules of Professional Conduct for inclusion of anti-discrimination language. I won't rehash all of the history of this amendment, which we covered in the June 26th meeting. And again, thank you for those of you who joined there. Suffices to say, there has been a long history of efforts by the State Bar to broaden and to include anti-discrimination language in the preamble. There was an effort 10 years ago that ultimately went to the Supreme Court and was not, it has set with the Supreme Court for, was not adopted by them as a rule change as a change to the preamble. And it seemed to me it was time to revisit that and see if sort of where the sentiment was of the council and their profession with respect to a change to the preamble. Just in June, there are a number of other potential changes that could be made, changes to other rules that would facilitate or perhaps enhance or accomplish or at least deal with this same issue. We're focused right now on just on the preamble issue. If you look at your agenda, you see there are other proposals which would deal with other parts of the rules, and we will get to those as we move down the agenda. But this matter is just on for discussion of the preamble. It was my thought that since the council had gone on record a number of years ago with respect to a change in the preamble, that that we would go ahead and bring this separately to see what the will of the committee was, so whether we would send this to subcommittee for study or whether we would send this directly to the council for publication. And I think we've explained the notions and ideas and given you the background. I will let Brian speak to this briefly on this, and folks, we'll take as long as y'all want to discuss this matter. I'd like to keep this focused on the preamble for right now. There'll be plenty of time to talk about the other issues that are involved, the rule changes that are involved. And we have received a good bit of email traffic that has conflated all three of these issues. It's the chair's belief that taking them up seriatim as we are, it's the best way to handle them. And so this will be a discussion on the preamble at this point. Obviously, the will of the committee is what matters here. However y'all want to handle it, we will. But to the extent we stick to the agenda, we would just be looking right now at the preamble issue. Brian, can you put a little more gloss on that for us, please?
Sure. Well, and I'm not going to, just as you said, David, I'm not going to go through all the history. We went through that pretty extensively at the prior meeting. And just for those that are maybe now watching this meeting and wondering what happened at that prior meeting, a copy or a recording of that June 26th meeting is available on YouTube. It's on the State Bar's YouTube channel. So if you're currently watching on the internet, if you go to the State Bar's profile, you will be able to find that meeting, and you can watch that meeting and the discussion that happened on those different topics, and particularly with regards to the history. But suffice to say, the very brief version is that, like David said, this was previously introduced back in 2010, but did not was passed by the council, but was not acted upon. But that vote for the council to approve the preamble followed nearly 3 years of different subcommittee studies and other votes and amendments to the preamble, or to the proposed language, I should say. At this time, you have in your materials I guess what we'll call the official copy of the proposed amendment. And this is the proposed amendment. It's to the preamble. Particularly, this would add a new provision in the preamble, and it's proposed that this would be under provision number 6, or what will be the new number 6. The language is as follows: while employed or engaged in a professional capacity, a lawyer should not discriminate on the basis of a person's race, gender, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. This responsibility of non-discrimination does not limit a lawyer's right to advocate on any issue, nor does this responsibility limit the prerogative of a lawyer to accept, decline, or withdraw from a representation in accordance with these rules. Now, just as far as the source of this language largely mirrors the language that was previously proposed in 2010. And if you go on just a couple pages past the official statement of the proposed language or amendment to the preamble, you will see, and I'm particularly looking at, if you're looking at the PDF of the agenda, page 11 of 310. Page 11 of 310 has kind of a track changes version comparing the current language with the old language in 2010. Really, the big thing that was added here to this current proposal were 2 additional statuses that were contained in Model Rule 8.4G, which we'll get into discussing, and I'm sure a lot of you are familiar with. But Model Rule 8.4G includes marital status and socioeconomic status as potential statuses upon which discrimination, could occur, and therefore is discouraged. And it also adds the last part of that last sentence: nor does this responsibility limit the prerogative of a lawyer to accept, decline, or withdraw from a representation in accordance with these rules. But largely, again, this language mirrors the language that was previously proposed. So as far as this preamble, again, I'm not going to dive into the Rule 8.4G issue or the potential amendment to the rule. But just kind of as a reminder or a summary of some of that discussion in June, the preamble, this particular provision, or this particular proposal, would be the first, as far as what we can tell, where a state's preamble to the rules of professional conduct actually states this aspirational goal. And of course, that is kind of a key aspect of the preamble, that the preamble states the different values of our profession, and is not necessarily enforceable as a rule that can result in discipline. But it is something that is supposed to collect and reflect the general standards and values of the profession. So with that said, that is the proposed language for the preamble. Again, if you just want to look at the language and the language alone, I would encourage you on our agenda to look at page 8. Page 8 of 310 is the official version. If you have questions about the differences between 2010 and now, look at page 11 of that PDF.
Thank you, Brian. And we're now, the chair would look for a motion. The motions would either be one, to send the matter to the council for publication and comment by the public, or 2, to send the matter to subcommittee for further study on the preamble. That's just as it would with any matter that comes before the ethics committee. Those two options are always available to us. So the chair would look for a motion either to publish or to send to subcommittee, and we can then begin a discussion.
I see Bill Mills has his hand raised. Oh, hang on a second, Bill. You need to unmute yourself.
Okay, I move that we send it to council for approval and adoption.
Okay, that would be the motion to send to the council for publication to the and comment. Is there a second to that motion?
This is Ted Edwards. I would second that.
Okay, thank you, Ted. Okay, now we have a motion to publish and a second. So now the floor is open now for discussion.
Ripley Rand.
Patrice, I don't know who else's hand is up, but I can see a couple of hands up.
Okay, I see Ripley Rand has his hand up.
Morning, everybody. Okay. In reading through these materials and in the discussion that we had at the last meeting about the preamble and the information in the scope, I would propose an amendment in a couple of ways. First, I would propose an amendment to remove the second, third, and fourth words of the proposed additional section of the preamble that says while employed or engaged in a professional capacity. As we talked about at the meeting, there are several other contexts in which lawyers operate in a professional capacity that don't involve necessarily being employed or engaged. This committee meeting, I think, being one of them, and other public service contexts when lawyers are in a professional capacity when they may not be employed or engaged. And so I would move that limitation be removed from the language so that it would just read while in a professional capacity. And I would also move that the language be changed from a lawyer should not discriminate to a lawyer shall not discriminate. The first sentence of the preamble says that a lawyer, as a member of the legal profession, has special responsibility for the quality of justice, and fundamental to the fair and impartial administration of justice is that none of the stakeholders engage in discrimination, whether you're talking about jurors, parties, lawyers, judges, anybody else in the court system. And a lawyer in our preamble has a special responsibility for the quality of that justice. And I think we owe it to our fellow members of the bar who have been subject to discrimination based on race or sex or sexual orientation or disability or anything else to make a strong statement in the preamble, even if it's not enforceable as a rule, to say that a lawyer shall not discriminate on the basis of any of those categories. And so I would move to amend the language to reflect a stronger statement rather than just an admonishment about what lawyers should not do, but that lawyers shall not do that.
Okay. Ripley, can you, but before we move on procedurally, that's an amendment. We have to go through that procedure. Let me just get you to read, since you made a couple of changes, if you would just read the language as you would have it, as your proposal states, if you don't mind.
So the proposed language that I would offer would read as follows. While in a professional capacity, a lawyer shall not discriminate on the basis of a person's race, gender, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. This responsibility of non-discrimination does not limit a lawyer's right to advocate on any issue, nor does this responsibility limit the prerogative of a lawyer to accept, decline, or withdraw from a representation in accordance with these rules.
I'll accept that as an amendment to my motion.
Okay. And then Thank you, Bill. If this is an amended motion as opposed to a substitute motion, and so as I understand the rules and the way we would do that is this is the proper procedure is for the original movement to accept the amendment, and now we need to know whether Ted agrees to second the amended motion.
I agree.
Okay. Now, thank you both, gentlemen, and I think that's the proper way to do this. You can see on your screen that Brian has put on the screen the language so that folks can see what this would look like.
And if David, if I can pause just 1 second, Ripley, can you take a look at the screen and confirm that I have captured your amendment?
Let me get my bifocals working the right way here on my phone. Yes, that is correct. Thank you.
Thank you.
All right. So folks, now the discussion is on the motion for publication of this amendment to the preamble as amended here today. So further discussion, questions, comments from the committee. All right, I don't, Brian, you have to check me on this. I don't see anything further.
Amy Hunt has raised her hand now.
Thank you. And I'm not trying to speed, guys. I just can't. I don't have the full gallery. So so Amy, go ahead, please.
Good morning. Thank you, David. I don't want to get too far into semantics, but I think shall becomes a pretty litigated word. I think it's not as firm as I think perhaps what we're trying to say. I agree with the sentiment of what's been proposed. I just wonder if maybe must or will is a little clearer. I think shall is just one of those words that can mean permissive and it can mean mandatory, and it gets litigated a lot. And I'm just trying to avoid any confusion in what we're saying in this preamble.
Okay. Thank you, Amy. Further questions or comments?
David, I don't know how to raise my hand. I'm not trying to be rude. This is Jack.
Yeah.
I'm raising my hand. I agree with what Amy just said. I think that may be taking us into a very complicated area. The shall language. I'm not sure. While in a professional capacity, a lawyer shall not. And a lawyer and Ripley, if you help us out here, you're taking out engaged in professional capacity so that we encapsulate functions like this right here, or say the meeting discussion. Am I still in a professional capacity if I'm in the state bar meeting and you and I are having a discussion and I share my Hindu belief about something related to socioeconomic status that triggers you? I guess I'm trying to, when we get to the shall language, I don't know what that looks like. I don't know what a hypothetical would look like that the shall then doesn't become some kind of disciplinary trigger for the expression of a, say, Hindu belief at a bar cocktail party.
Okay. Thank you, Jack. Other questions or comments?
Amy Richardson has her hand up.
Okay, Amy, please go ahead.
Good morning, all. I just wanted to point out on the shall language, just two things, and Brian and people who love the rules also help me with this, but I think the rules really like the word shall, believe it or not. Like, I was just double checking, it's an often used word. But the other thing too is this is in the preamble, so I understand some of the concerns, but I'm not sure if it is as developed, given that there's not violations to be had here, but happy to be checked on that statement about shall.
Yeah, I'll respond to that. The generally speaking, I think the rules, the context of the rules themselves do reference shall, or you do use the term shall, because shall is an enforceable word. And that's where I was just scanning the preamble to ensure that my understanding is correct. And of course, Nicole and Suzanne are my co-experts as well. But I believe the preamble typically does use the word should. And that is because of the lack of enforcement that we have with the preamble. We only enforce the rules and the text of the rules at that. Of course, the comments can be used to understand how the rules are meant to be interpreted. But mainly when it comes to disciplinary issues, it's all about the rules. We do not enforce violations of the preamble. And so that's where, as I was just looking over the preamble again, I do not see the word shall. I don't know if that's if I'm missing something, but I would ask Suzanne and Nicole to weigh in as well. But I do think that the preamble mostly uses the word or the term should as opposed to shall, for whatever that's worth.
Okay.
This is Suzanne. Yeah, I think it should all the way through. And I think just for consistency's sake that we might want to continue to use should.
All right.
But
I see Warren
I have a
Savage has his hand. Oh, sorry, Nicole. Yes, please.
I'm sorry, I can't figure out how to raise my hand. I think I did the clap hand, but I'd like to make a suggestion about the language for purposes of making sure that we have a verb. And maybe it should say while acting in a professional response or a professional capacity. So adding the word acting.
That would be Nicole's suggestion.
Let's don't lose the track of right now. What's in front of the committee, what has been moved is Ripley's substitute or amendment, which is as reflected here right now. Ultimately, if we decide to make other words, we'll have to make sure we have the proper language in front of the committee for its consideration.
That's correct. Warren Savage has his hand up.
All right, Warren.
I'm sorry to go back to square one, but the motion is to approve what language here and do what? Send it to the council to send to the Supreme Court?
This would be for publication.
For publication. Okay.
Yeah, it would go.
My question is, at the last meeting, there was some discussion amongst the group, including, I remember, Judge Parker Dunstan, questioning whether we should do everything as one package if we're going to try to consider adding Rule 8.4G or whatever it would be in our rules, along with the preamble, rather than presenting, some half measure that might create the ability to avoid the real issue, and that is whether we're going to do the rule or not. So I just put that out there for consideration, maybe to send this instead to that same subcommittee and have it all considered together. Although I appreciate the timeliness of this and that it was passed in the past and sent to the Supreme Court, and that we want to reassert our position, but I don't want to make it any easier to avoid the real issues that I think we're going to have to face with Rule 8.4G. That's all I got to say.
Well, I will step aside from being chair for just a moment to say there's no attempt, of course, to avoid dealing with the issue. That's why we put this on and highlighted what our as I've called it, a basket of options for us here to do 1, 2, 3, all three, any one of those that we wish to do. The committees, and one of the things we generally try to avoid, and Warren is right in this regard, if we're going to be editing this a proposal sort of as a committee on the whole, that's generally not the best way to handle matters, and we may want to send the whole matter to a subcommittee. My thought had been that since this had been adopted previously, that the Ethics Committee might want to go ahead and take this step while we considered other steps. Certainly the will of the committee is what matters. And if folks want to consider the whole basket of options in together, then we would the motion by Bill and Ted to move forward with publication should be voted down, and we would then have a motion to send the matter to subcommittee. And so that's really sort of where we are. We're at a decision point when we get ready to vote on whether we would publish this or send it to subcommittee. I see another couple of folks have raised their hands.
Yes, Bill Mills has his hand up.
David, I would like to amend my motion, subject to Ted's hopeful second, to reflect the issues that were raised by staff and others, particularly that after the word while, put acting, and then to be consistent with the rest of the preamble, I think that rather than shall, I think it should be should. And so I would like to amend my motion so that the wording would be, while acting, blah, 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 a lawyer should not discriminate, blah, blah, blah. That would be my amendment. Ted?
Yeah, Ted, what's your say?
Yeah, I'm taking a minute. I was waiting for Brian to change it so I can see what we're saying now, because we're going back and forth.
Yep.
It's accurate now.
All right, so
it would read, folks, while acting in a professional capacity, a lawyer should not discriminate on the basis of a person's race, gender, national origin, other categories.
yeah, I'm fine with that.
Okay. But that's the motion in front of the committee then, is this language that appears before us: while acting in a professional capacity, a lawyer should not discriminate on the basis of the categories we list.
I see Steve Robertson has his hand up.
All right, Steve.
Good morning, everyone. I just want to get behind Warren's position and suggest that we vote no on the motion before the committee and send this whole package to subcommittee. I think we're pretty deep into contemplating our navel, as we're wont to do. And it may make sense, rather than to have the whole group of 40 of us get too deep into just, it's a big issue, it's an important issue, and it probably needs more study. So I urge everyone to vote no and send it to subcommittee.
Thank you, Steve. Other hands?
We do not have any other hands raised.
Now we have Dorothy.
Oh,
Yep.
sorry, Eben.
Dorothy first, then Eben.
All right, Dorothy.
Good morning, everyone. I know I'm not on this committee any longer, but I would like to encourage you all to vote this down, as Warren has indicated, as well as Steve, for the reasons that have already been stated, but also I would reiterate what I stated in the special committee meeting that we had a couple weeks ago, that, you know, as a member of one of these groups, or actually several of these groups, I would not want any of our members or the general public, anyone that's a part of any of these groups, to feel as if we are trying to appease them in some way, and that by just saying we are encouraging our lawyers and other members to not engage in this kind of discrimination. But we want to have some meat to it. And what I didn't say the last time, and I've thought about since then and want to say, is that what a lot of people are not saying, and I'm going to go out on that limb and say, is that a lot of our members, especially of the African American group, feel as if the state bar itself does not always abide by these goals, that sometimes they feel discriminated against by the state bar. And so I would hope that we would do something to lessen that viewpoint, of our members and that in the African American group or Black and for just people in general. And I know that's not something that a lot of us think about or a lot of others don't think about, but that is a very real notion and feeling that our members do have. And so not only do we need to further something like this or further this just because it's the right thing to do, I think it's something very important that we are careful about as the state bar and how we go about it too, because we want to make sure that we, like I said, help lessen those feelings or at least alleviates them for some folks at the very most. So that's what I wanted to say. And thank you for giving me the time to be able to speak, knowing that I'm not on this committee.
Dorothy, you're one of our alums. So not only all council members and all guests, frankly, are encouraged to speak, but certainly our alums who've had to put up with us for years previously are always welcome and invited. Thank you, Dorothy. Evan, I think, was next.
Yes.
Evan?
Evan, you're muted.
Am I unmuted now?
There you
go. All right. Good morning, Mr. Chairman and everybody. I think I see this as a little bit differently. I see each of these three issues as containing separate and discrete differences that need some exploration and study. But I also see the preamble as an opportunity that right now that we can pass, not send it to subcommittee, publish it and get it out there so that it kind of lays the groundwork for the subcommittee work that should go on 8.4G and the comments on 1.1. The comments on 1.1 I see as tied to this very important issues surrounding CLE on diversity and inclusion. And I've been talking with James Williams and some others about that. And I see an opportunity for a subcommittee to really dig deeply into the 1.1 comment and make some recommendations that are particular to that issue. Likewise, the other rule, 8.4G, has another subset of issues that is different than 1.1 and different from the preamble. When this was last studied back in 2010, David, I think you were involved in that, but it ran parallel with the Ethics Committee study of placing duties on prosecutors to disclose information or evidence of innocence, and that also was voted down. I was fortunate enough to be on the subcommittee that revisited that a few years ago, and we looked at the ABA model rule, and we looked at the three different duties that were required under the model rule, and we took the first one first by itself, and it passed, and it passed the council, and the Supreme Court has, of course, approved it. And I see the preamble here much in the same light, that this is an opportunity for us to move now to demonstrate our aspirational goals and not get this conflated with rule violations or rules. I think there's two separate things, and I would encourage the committee to vote yes on the preamble. Let's get it out, and then let's look at these other two issues. And my recommendation would be that we appoint two separate subcommittees, one for the 8.4G and one for the comment to 1.1. So because I see that they just got different landscapes on both of them. So let's vote the preamble, because I think it's something that we all can get behind and not have it. This is like Congress trying to put riders on bills and tag everything along. I think these stand separate, and I encourage everybody to vote for Bill's motion. Thank you.
Thank you, Evan. Other comments, questions?
Dorothy has her hand raised.
Okay, Dorothy.
I have a question. Is it possible that if this does get passed, that when this goes out for publication, that there's a caveat put with it that these other rules are being looked at also?
Well, certainly the procedure would be that if the next two are sent to subcommittee, there wouldn't be a we can I don't know how we would note that, but yes, I mean certainly that will continue. Those matters next on the agenda would be assigned to subcommittee to move forward on their own track. This one would go forward to the council on Friday for publication if that's how the committee votes. But I don't know.
Yeah, David, I can.
I guess what I'm asking is that would it be able to have a caveat to the public that these other rules are being looked at? Because what I'm concerned about is that folks seeing this and saying, "Oh, this is all they're trying to do." You get what I'm saying?
Yeah, I
got you.
And that's what I was going to add. As far as the publication, we publish this on our website. We publish it in the State Bar Journal, excuse me. And then, we typically, we've been trying to engage more on social media and so forth with different things that have been published. But I would envision that this would, of course, be published in those different mediums as we traditionally do and as we're required to do by our administrative rules. But also that the appointment of the subcommittee would be noted in our ethics article where we summarize what happened during this quarter. And we actually spoke about this during the communications committee meeting last week, that should this subcommittee be appointed and the bar engage in this discussion, that could be a focal point for State Bar communications and particularly for counselor engagement with their districts. So I think there's a variety of ways that we can and would want to get the word out that the bar is engaging in this discussion, particularly to solicit that feedback and participation.
Dorothy, does that answer your question, Dorothy?
It does answer my question.
Thank you.
I see Jack Lloyd and Alice also have their hands up, so we can go Jack first.
Hey, yeah. So just to clarify my point, because now it's been stated with much better clarity than my lack of caffeinated brain was able to put together, and I was stumbling through that. So, right, I think these points have been great and helped me see better what the point is. I may completely agree with Ripley Rand's the sentiment behind that, and my fear was just initially in the preamble setting when we lack this space to go with the specificity that we're going to be able to clarify in the rule. That was my only concern, not the topic itself, not the sentiment itself, just that the difference between a generic statement using language, which I think probably better fits into what we're going to do, which is in the rule itself. So just to clarify my point, because I agree with what has been said for the last number of speakers here, Dorothy and Evan, and I think that they have really helped shape that better in my mind. So again, that's my only point, and I just wanted to clarify that. Thank you very much.
Okay.
Thank you. I think Alice had her hand up. I don't know, but I see it's been lowered again. Alice, did you have anything to add?
I was just going to respond to Dorothy's request that the journal make it clear that not only are we proposing the preamble amendment, but we're also studying 8.4G. And since I write the proposed rule amendments article, I was going to suggest that we actually do a little sidebar and make that point when we're publishing the proposed amendment to the preamble. So we will do that. I think it's a good suggestion.
Oh, sir. Okay, did I see Warren's hand up too?
Yes,
I'm sorry.
Warren's hand is up.
Okay.
My only, just to reiterate what Dorothy said earlier about a perception among some folks in our bar about our organization. I want everybody to think about passing a preamble and then being unable to do anything with 8.4G and what light that puts our organization in. So I think we need to put all of it in the subcommittee.
Okay, thank you, Warren. I can't, from my screen, I don't see any other hands. Are there additional hands, Brian, that you see?
I do not see any other hands.
All right, folks, the matter, I believe, is then ready for vote. And I want to say this, that part of the reason for having the special meeting previously with all of the proposals there, and part of the reason that these have all three moved forward is, in fact, to emphasize to everybody that this is the full range of responses is what we're trying to get to. It's what we're trying to address and see what we can do on the full range. And that's been why we've linked them all together, and why we've really had a sort of, I think, particularly with the YouTube streaming and with the special meeting, an attempt to let people know what are the options, what are the available resources that we're looking at to try to address this, so that it can all be done, and not as where it's just like we're going to do one thing and shove the other ones aside. That's certainly not been the intention in raising them the way that we have. The proposal in front of us is to send to the council for publication the language that is in front of you on the screen. I will read that for you to make sure. While acting in a professional capacity, a lawyer should not discriminate on the basis of a person's race, gender, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. This responsibility of non-discrimination does not limit a lawyer's right to advocate on any issue, nor does this responsibility limit the prerogative of a lawyer to accept, decline, or withdraw from representation in accordance with these rules. That's the motion before us to send to the council for publication. All those in favor, please signify on your voting bars by voting aye or voting no.
I believe that has concluded the voting. If anybody has a vote, please do cast it now.
If you're unable to find the yes and no buttons on the participants tab, they're at the bottom. But if you're still unable and would like to add a voice vote, just let us know.
All right, I believe that is everyone. We have 23 yeses and 5 nos.
All right, the matter is sent. Thank you, ladies and gentlemen. The matter will be sent on to the council on Friday for publication. Brings us to the next matter, which is number 3, proposal study and consideration of adopted model rule 8.4G or revised. I'm happy to combine these if it's the will of the committee with the next proposal. There are, I think Evan sort of set them out. There are 2 different really kinds of proposals here. One with respect to whether a CLE component would be added. The other with respect to whether there'd be a change in the actual rule analysis. Brian, you want to give us, and we've highlighted these again in the earlier meeting. Brian, just give us a little bit of a highlight here. I will tell you, folks, we've received voluminous material on this. I mean, hundreds of pages and dozens of emails. Some of that, a sample of some of that was included. That is, we did not include everything that we have received just because didn't want to fill up EDDS with all of those pages of material. Stuff continues to come in. Stuff came in today. All of that will be available if this were to go to subcommittee. All of that will be available to the subcommittee. All of that commentary will be sent to subcommittee for study. But there's a lot of materials that has come into the State Bar, to Brian and to me on both these proposals, and that will all be available to everybody if that subcommittee is appointed. Brian.
Yes, and just to follow up on that, to anybody who's watching on YouTube who had submitted something, and perhaps you submitted it yesterday or even just a couple of days ago, as David said, not everything is in there in the agenda materials, and that's primarily because this the kind of the procedural aspect of this, or where this proposal is at. It is a proposal for a subcommittee. So if you submitted comment, please know that your comments have been preserved. They will be shared with the subcommittee and ultimately be included in all the different materials that that this committee looks at the appropriate time. But we did provide a sample of some of the information. Of course, that addendum was published on Monday. So anything that came in after Monday was not included in your materials. But as David mentioned, yes, we have received a lot of different emails, both in support and opposed to the adoption of Model Rule 8.4G. Just as by way of brief background, because of course we covered a lot of this at the June meeting, but the materials that you have in your agenda reflect kind of the current status of really what I'll just say is anti-discrimination language that's been adopted into either the text of the rules of professional conduct in the different jurisdictions or the comments to the rules of those different jurisdictions' rules of professional conduct. That is not to say that everyone has adopted Model Rule 8.4G. In fact, Model Rule 8.4G was only adopted in 2016, and it's, to my count, I believe only maybe two jurisdictions have adopted the actual language from the model rule. A few jurisdictions have adopted kind of a version of or a slight alteration to Model Rule 8.4G. But the number that you see in your materials, namely that 37 of 51 United States jurisdictions, including the District of Columbia, refers to really anti-discrimination language that has been incorporated into their rules or into the comments to their rules. You know, all that's to say that, and I guess I have to add also that a number of jurisdictions have had this conversation that's being proposed now, and they have determined that this rule is not appropriate for their jurisdiction. They have rejected the rule or rejected including anti-discrimination language in the text of the rules of professional conduct in that jurisdiction. So this is a conversation that has been had by the vast majority of jurisdictions. And it's now proposed that North Carolina also engage in that conversation to determine if such anti-discrimination language should be included in the text of the rules of professional conduct or perhaps in the comments to the rules. And just by way of kind of clarification, the comments what I'm referring to typically link the anti-discrimination language to Rule 8.4D, which says that it's professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice. They essentially tie this anti-discrimination responsibility to that particular rule. But nevertheless, this proposal is to engage in that conversation via subcommittee. And like David said, we have a lot of different comments already. I'm sure we'll get more. And to that end, I'll add kind of at the end of the meeting, when we're wrapping everything up, we've actually created a new email account for folks to send their comments in, and that's ethicscomments@ncbar.gov. I'll put that on the screen a little bit later. But nevertheless, if somebody does have comments, we're going to switch that over to ethicscomments@ncbar.gov, if only to save me from the constant pinging of emails that were coming in, which of course we certainly do appreciate, and we want people to offer their opinion. So nevertheless, that's the proposal that's on the table. David, do you want me to give any more background, or you think that's sufficient?
No, I think that's sufficient. Let me do two things for folks who are not familiar with the way things work. Again, as I said, in the Ethics Committee, we will have either a matter will be sent to subcommittee for study or sent on to the council for publication. During that period, we receive comments when the matter is before the subcommittee. If the subcommittee consults other jurisdictions, we send it to all of the voluntary bars to get information from them, and try to get input there, so that it is vetted out. All of the comments coming from the public then are channeled in to staff to present to the subcommittee for their consideration. So all of that material that you have sent in, if you're part of the public or part of the profession, all of that will be considered and put before the subcommittee or the full committee for review. The proposal is to consider current ABA Model Rule 8.4G, which says it is professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from a representation in accordance with Rules 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules. That's the model rule. As Brian says, it's, other states have modified it, adopted it, changed it, rejected it. All of that has been out there. So what we would be looking for now is, so that we can start a discussion, would be a motion to send Rule 8.4G to a subcommittee for review and study, or of course, alternatively to the council to be adopted, the council for publication. But the normal procedure would be to appoint a subcommittee to study the matter. So the chair awaits the committee's will on that regard.
And Eben has his hand up.
Mr. Chairman, I'll make a motion that we send this to subcommittee for study and a report back to the full committee.
Thank you, Mr. Rawls. Second, I heard a second out there. Okay. Matter's been moved and seconded that we send Rule 8.4G to a subcommittee for review and study. Is there commentary on comments, questions on that from the committee?
See, Ms. Lewis has her hand up.
Takia, yes, ma'am.
Oh, Takia, you're muted.
Yeah, I was trying to unmute. Sorry.
Okay, there you go.
I just wanted to say that I think that since this is going to subcommittee, that we should think about who is actually on the committee, the subcommittee, especially trying to make sure that we involve people who fall into multiple categories of the groups that are discriminated against. For example, I fall into several categories, just like Dorothy said. So my experience being a Black woman attorney in a rural area is going to be much different, my perspective, than an older white man in a city. So I think that it's going to be very, very, very important to have as many people who fall into those cross sections as possible on the subcommittee.
Thank you, Takia. That's yes, and they will also be having advisory folks to make sure that we cover to try to make sure that we are as inclusive as possible. And also, of course, as all of you know, the matter subcommittee meetings are public meetings. They'll be up to be posted when they meet, and folks are, whether they're on the subcommittee or not, are certainly welcome to engage with the subcommittee at any time, either by sitting in on the meetings or by sending thoughts, comments to the subcommittee directly too. But yes, we'll be mindful to try to be as inclusive as possible in terms of setting up that subcommittee. Other hands, questions?
I do not see any other hands raised.
All right, in that case, if there are no other, then the matter is before us to, on Mr. Rawls's motion to send the matter to subcommittee for further study. All those in favor, please say aye. Or vote, I'm sorry, vote aye or nay.
I believe that, well.
I vote aye, I'm having trouble.
Okay, well then, including Ted's voice vote, then we have 27 yeses. It's unanimous.
All right, and for those of you who are interested in serving on that subcommittee, please let me know. Contact Brian or me to let us know if you have interest in serving. We'll be happy to consider. I do not plan to make, though, a 40-member subcommittee, although, as I said, we do encourage all of you to follow along, check the website, see what's where we are, and also to attend as many meetings as you wish of that subcommittee and to participate, whether you're on the subcommittee or not. For some reason, Brian, I seem to have lost my camera. Are you seeing me still?
Nope. We can still see you. So we're.
Y'all are getting the worst of that. I can't see y'all and y'all can see me. So please bear with me then. The next matter is number 4, adopting a new comment to Rule 1.1. This matter was also discussed at the special meeting. As you know, the CLE board is actually looking at issues to include diversity and inclusion as mandatory CLE categories presently. There is proposed language for a new comment that says competent handling of a particular matter includes a lawyer's awareness of potential cultural differences and implicit bias relative to the client or anyone involved in the client's matter that might adversely affect the lawyer's representation of the client. The lawyer should be educated regarding such potential differences and biases to ensure understanding of the client's needs, effective communication with the client and others, and adequate representation of the client. There's also been some alternative language placed before you. So the matter is before the committee for its will to send to a subcommittee for further study on adopting a new comment to Rule 1.1 on competency. Is there
Evan has his hand up.
Yes, sir. You're muted, Evan.
There you go.
All right, Mr. Chairman, I make a motion that we send this to a separate subcommittee for study and review and report back to the Ethics Committee.
Second.
All right, thank you, Bill. Thank you, Evan. The motion is to send to a subcommittee for study on additional comment to Rule 1.1. Are there questions or comments on that? And Brian, I didn't mean, do you have any, I'm sorry, I sort of cut you out of the picture. Do you have any additional comments on this before it goes to vote?
I have no further comments. I think you summarized it perfectly.
Okay. I don't see hands raised. Questions, comments? All right, in that case, all in favor of sending this matter to subcommittee, please vote yes or no.
All right, and it looks like that the voting has concluded, and this one is also unanimous. 25 yeses and 0 no's.
All right, thank you, folks. Appreciate your support on that. We'll get those subcommittees appointed again. If you have interest in serving on either of those subcommittees, feel free to let me know or to let Brian know, and also to follow along to, if you wish to participate or not on the subcommittee, to check the State Bar's website to find out when those subcommittees will be meeting. The next matter is another proposed amendment. This one is the amendment to Rule 1.5 on charging clients for responding to grievances. This comes to us from the Grievance Committee. And Brian, can you summarize where we are on this one, please?
Absolutely. So we have, and you have this in your materials. This is, if you're on the agenda, it's on page 55 of the PDF. But this issue was brought to our attention from the Office of Counsel, and the issue is this, that for some time, and I really have to say just historically, we have advised lawyers through the ethics process, as well as enforced the notion that a lawyer who charges a client for the time spent responding to a grievance complaint that the client filed against that lawyer, namely the lawyer is essentially charging for the client for responding to a grievance about the lawyer's own conduct, that is an excessive fee and that is prohibited by Rule 1.5. I think this comes as a surprise to a number of lawyers that I talked to about this, but lawyers do continue to charge. And we had earlier this year, the Office of Counsel noted that I believe there were as many as 3 different ongoing investigations where that particular issue had come up, where a lawyer was charging a client for the time that the lawyer spent responding to the grievance that the client filed against the lawyer, and was trying to collect on that. So the issue was brought to our attention, and as a result, David, as chair of this committee, and Todd Brown, as chair of the grievance committee, appointed a joint committee to look at this particular issue. The members of that committee, Fred Morlock, who's here on the call today, was the chair. Dorothy Hairston Mitchell, Anna Hamrick, Alan LaCroix, Takia Lewis, and Steve Robertson. We met and discussed this potential, this proposal for a new rule. And I think it was, rather unanimous that if the rules don't say this, then they should say this. And I will kind of expand a bit on the confusion, because we did talk about how this seems to be a general understanding in the profession. And be that as it may, when it comes to enforcement of the rules, we can't enforce general understanding. We have, like I said, always said that this falls under the excessive fee rule and the excessive fee prohibition, particularly because you're not charging a client for services. You're charging a client for complying with your professional obligation. There are some ethics opinions out there, and you'll see a memo that kind of summarizes the discussion that occurred by this appointed committee on page 56 of the PDF. But there are some ethics opinions out there that we have in the ethics department have historically used to explain this particular matter and to clarify to lawyers that they cannot do this. But those ethics opinions, one, do not address this particular situation of a lawyer charging a client for responding to a grievance. They address withdrawing from a case and how you can't charge for withdrawing from a case or charging for participating in a fee dispute. And it just kind of comes out to that issue that ultimately the state bar cannot enforce ethics opinions. Ethics opinions can be used as persuasive authority, but there isn't a specific prohibition on this type of conduct. So the committee discussed it, and the committee ultimately concluded that this should be prohibited. If it's not already, it should be prohibited. And that's what results in the rule amendment that you find in your materials. The rule amendment, as well as a comment explaining the rule amendment, is found again on page 55 of the PDF. The rule amendment would state as follows. Under Rule 1.5, this would be new provision, subparagraph G. A lawyer shall not enter into an arrangement for, charge, or collect anything of value for responding to an inquiry by a disciplinary authority regarding allegations of professional misconduct by the lawyer, for responding to a client security fund claim alleging wrongful conduct by the lawyer, or for responding to and participating in the resolution of a petition for resolution of a disputed fee filed against the lawyer. The comment that's being proposed would be a new comment as well. Comment 13 would read, lawyers have a professional obligation to respond to inquiries by disciplinary authorities regarding allegations of their own professional misconduct, to client security fund claims alleging wrongful conduct. And excuse me, I realize that I need to actually go to the addendum. The addendum is where you have, I apologize for that. The addendum is where you actually have the updated language. There was a little tweak to the comment that we wanted to include here. And I'm actually just going to go ahead and try to put this on my screen so we're just all on the same page. But the addendum, like I said, is the one that has the updated language. The Office of Counsel noted a slight tweak to the comment that they wanted to incorporate. So as you'll see here, of course, the G, or the proposed text for the rule remains the same. The comment says, lawyers have a professional obligation to respond to inquiries by disciplinary authorities regarding allegations of their own professional misconduct, to respond to client security fund claims alleging wrongful conduct by the lawyer, and to respond to and participate in good faith in the fee dispute resolution process. It is improper for a lawyer to charge a client for the time expended on these professional obligations because they are not legal services that a lawyer provides to a client, but rather they advance the interests of the public and the profession. So again, I apologize for that confusion. The language that I would like you all to look at and what's before the committee is as a staff recommendation for publication is on your addendum materials. It's page 51 of the PDF, of the addendum PDF. So that is the background. Again, Fred Morlock is here. I don't know, Fred, as chair, if you would like to offer any thoughts.
Thank you, Brian. One of the discussions we had was whether a lawyer who was being sued for malpractice by say a pro se plaintiff, former client, could respond with a Rule 11 allegation and possibly collect fees from the court, and that this would not be an action subject to this rule. We had some other discussions about outlier issues. Really can't remember right now, but I wanted to make that comment and make that clear. But if there were other outlier issues, Savannah or Brian, you might have those that would fall outside of the rule. Thank you.
Now, I'll just add, I think you're right, Fred. That was I guess the primary one, whether or not this was supposed to cover any sort of potential request for attorney's fees by an attorney who was being sued for malpractice and prevailed. And that's not supposed to be covered by this particular rule. This is supposed to focus only on responding to these different, I guess, professional obligations, responding to a grievance complaint or a client security fund claim, or participating in the fee dispute resolution process. I think Warren has his hand up.
Yeah, Warren, before, yes, Warren, what's your question or comment?
You go ahead, David.
I just wanted to say we probably need a motion to get this matter actually before the committee. And Alan, I'm not to jump Fred, but Alan LaCroix, you're a member of our committee and on this subcommittee. Do you have a motion to send this to the council for publication?
Yes, also move it to council for publication.
All right. Is there a second to that?
I'll second, since I'm unmuted.
Okay, thank you. Now, I'm sorry, Warren. I just want to get the niceties out of the way. Now, Warren, please go ahead.
So as far as, in general, I agree with this completely, except for the one situation where I was wondering if y'all considered grievances brought by pro se opponents against the lawyer. And this is not a client, it's not a former client, but also oftentimes a pro se opponent uses the grievance process in an attempt to gain leverage or otherwise harass the client and the lawyer. Is there prohibition? Was there a discussion about whether this reached that situation? As anybody on grievance knows, a complainant can lie their way past a 12B6 standard and force the lawyer to respond to a notice of grievance. And I just didn't know if there was discussion of that, or whether our professional obligations requires us not to charge our client for responding to that grievance. That's all I got.
I mean, I would leave this to the committee members to add, but I do remember we did discuss that at the committee, and I believe the committee, I guess we talked about a couple of things. One, just the general professional obligation to participate in the disciplinary process, and also the I guess just the general notion that when somebody files something with the state bar, as much as, whether it's a client or an opponent, whether it's opposing counsel, hopefully not opposing counsel, but the essential notion that that if somebody provides something that essentially gets past what you mentioned as the 12B6 standard and results in a letter of notice going out and a response being required, that is a part of the disciplinary process. That's a part of the investigatory process to flush out just what misconduct, if any, occurred. But that also, and I specifically remember Takia had raised this point that, kind of the question of people using the grievance process as a harassment tool. And that's where, Catherine Jean was on the call, as well as Savannah from the Office of Counsel, and just noted that, we do at the State Bar, and particularly in the Office of Counsel, have, I guess, kind of an eye on the frequency of complaints and particularly the source of complaints. And so if somebody files 15 different grievances against the same person, the lawyer is not going to be called upon to answer 15 grievances necessarily. That there's an initial investigation and review and determine if they all need to be consolidated, or if this is the same person that continually is just peppering the State Bar with complaints that are unfounded. And the Office of Counsel has its own, I guess, filter for those issues. So, but ultimately, I think that's where the committee ended up on the position that this does apply to just generally the lawyer's responsibility and in participating in the self-regulation of the profession, kind of regardless of the source.
Great. I mean, that answers my question that it was at least considered, and
Yep.
I have no problem with the proposal.
Other questions or comments? All right, if seeing none, Brian, keep me straight. I'm sure you don't see any, do you?
I do not see any. There are no other hands raised.
All right, then the motion is to send this matter to the council for publication on Friday. Please vote yay or nay using your buttons, and if you have a problem, just let us know.
And there's one more that trickled in. I believe we are at a unanimous vote, 26 in favor, 0 no's.
All right, thank you, folks. Normally we've been up for about an hour and a half. We take a little break. I'd like for us to continue to move forward and just sort of see where we are. Our agenda is quite long, but I think some of the matters may move fairly rapidly. So if you need to adjourn for a moment, we understand that. I'll be mindful of that, and certainly we'll check again in 15 or 20 minutes to see if we need to go ahead and take a break for all of us. The next matter is communications. Oh boy, one of our old favorites. This will be subcommittee reports. This is 2019 FEO4 communications with judges. Don't know how this actually has a 2019 matter number on it. It should have had a much, certainly been around a lot longer than that. But we've reconstituted the committee. Committee is to study communications with judges, and that's Judge Rader's chairs that committee. Is there a motion from the subcommittee?
Yes, Mr. Chair, the subcommittee met on June 29th, and at that time we had a proposed draft that staff had formulated. A lot of thanks to Brian and Carmen Bannon for their work on that. That draft was very well received by the subcommittee. We think we got we're at a very good point. I would say we're real close to having this finalized. We gave some direction to staff when they went back and started to tweak it. They realized there are 1 or 2 minor issues they wanted some more input from the subcommittee on. We didn't think that we had sufficient time between June 29th and today to get another meeting scheduled and get the draft finalized. So for those reasons, we would ask that it be returned to subcommittee with our intention of bringing a proposed opinion to the full committee in October.
Was that a second? I'm sorry. Okay, thank you. That's been moved and seconded that the matter be sent back to subcommittee. Is there discussion on the motion?
No hands are raised.
All right, all those please vote to send the matter, yay or nay, to send the matter back to subcommittee.
I believe this is a unanimous vote, 23 yeses and 0 nos.
Thank you, ladies and gentlemen. Next matter is inquiry of staff advancing client portion of the settlement. This is Nicole.
Yes. So this is an inquiry that has been under subcommittee review since October 2019. This proposed opinion discusses Rule 1.8E's prohibition on a lawyer providing financial assistance to a client in connection with pending or contemplated litigation, except for the court costs and expenses of litigation. The focus of the subcommittee discussions have been around on defining what is pending and on a determination of when litigation is no longer contemplated. After a subcommittee conference call in January, the proposed opinion was revised. Inquiry number 1 involves a lawyer filing a lawsuit for a client, but settled the claim prior to trial. Prior to the lawyer receiving the release and the settlement funds, the client asks for his share of the settlement. The opinion defines the term pending and states that an action is deemed to be pending from the time it is commenced until its final determination. The opinion concludes that the lawyer may not advance the client's share of the settlement until the release is signed, the settlement funds are paid to the lawyer or the client, and an order dismissing the lawsuit is filed with the court. And inquiry number 2 addresses when litigation is no longer contemplated after the lawyer settles the client's matter, but prior to filing a lawsuit. The opinion concludes that whether a matter is no longer contemplated under Rule 1.8E must be determined individually by the lawyer based upon the circumstances, and the opinion also sets out examples for factors for the lawyer to consider. If the lawyer determines that litigation is no longer contemplated, then any advance to the client is considered a loan, and the lawyer must follow the requirements of business transactions with the client under Rule 1.8A. The lawyer must also comply with the requirements of Rule 1.15 on trust accounting and keep detailed records of the transaction. Inquiry number 3 addresses the lawyer's ability to advertise, the lawyer's ability to advance the client's share of the settlement prior to the settlement check clearing the lawyer's trust account. The opinion points out that because each case is different and until the lawyer can determine that the litigation is no longer pending or contemplated, advertising the ability to advance the client's share of the settlement is misleading and creates an unjustified expectation about the lawyer's services in violation of Rule 7.1A. The subcommittee met again in March of 2020 and revised the opinion further. Opinion number 1 remains unchanged, except there were a few minor changes to clarify the facts. Inquiry number 2 was divided and now is in 2 separate inquiries. Revised number 2 will include that the lawyers may not advance the client's share of the settlement if litigation is still contemplated, notwithstanding a pre-suit settlement. So it will follow everything that I just stated in inquiry number 2. The new inquiry number 3 will separate out the language regarding doing business with a client under Rule 1.8A. And then what was formerly number 3 that regarding the advertising was renumbered as number 4.
Okay. Thank you, Nicole. Mr. Savage, this I believe is your subcommittee.
I'd move that this be published for comment.
Is there a second?
Second.
Thank you. As I hear a second. All right. Questions, comments, discussion from the committee with respect to this matter?
I think we got it right.
We've been studying it for long enough.
Yeah.
Well, and I will add that I'm aware of at least one other comment that will be coming in. So I imagine that the subcommittee will have some additional perspective to consider. And to that end, we may go ahead and schedule a subcommittee meeting prior to the October meeting after comments have been received, so we can be prepared to address any considerations that get brought to our attention at that time. Stuart has her hand up. Stuart?
Yes, thank you, Brian. I appreciate it, and Chair Allen. I was on the subcommittee. I do not like the outcome of this opinion, but I believe that it is accurate in terms of the rules. I'm a plaintiff's attorney. I've spoken with my plaintiff's attorney brothers and sisters, and across the board, most of them don't like it, although I have had one comment that was in favor of this opinion and also went further and said it shouldn't have the restrictions on it. So, I mean, that shows you the divergence of the opinions here. So I do believe, though, at this point, it should be published for comment. The comments that I've received against and in favor have not been grounded in the rules. And so I think that we did some deliberative study on this and reached a conclusion that is consistent with the rules, but may not be what we like or what everybody else likes. So I think it is right for comment.
Thank you, Stuart.
Jack Lloyd has his hand raised.
Hey,
Yes,
thanks,
sir.
Brian. Yeah, let me just reiterate what Stuart said, and just for anyone out there who's feeling swirly about or wants an opportunity because of their client base to help clients. I started out with this matter, as everyone knows, or most people in this committee know, I represent clients who don't have financial resources through legal aid, and so for me, this was difficult because I've had a lot of situations where clients needed help post-judgment, pre-collection, and I'm telling you, sometimes tracking down like a slumlord or something like that can take a long time to get that money. And I have clients who need basic necessities, and so I started out really apprehensive about any hindrance on or stifling on our ability to try and help. But I will tell you, I agree with Stuart. After you go through the process, not all of my colleagues who I spoke with like the outcome of it, but I do think it is right with the rules. And I want to thank our chairman for helping take some of my emotion out of it and put me into a more logical frame of mind. Because as Stuart said, I think this does really ultimately work with the rules, even if compassionately we would like a little bit more leeway or wiggle room to help. I do think this is the right decision, and we did talk about this and study it very, very extensively. So thank you very much.
Thank you, Jack. Other hands, questions?
I did not see any other hands raised.
All right. All those in favor then that, I'm sorry, I keep saying that, I apologize for that. Please use your voting buttons to vote on the motion. Which I'm sorry, is to send the matter on to council for publication.
And this one is unanimous, 25 yeses and 0 nos.
Okay, great. Next matter is moving on to reconsideration of prior inquiries. This is inquiry of staff responding to negative reviews online. This is, Gina, this is your subcommittee, but we'll have Suzanne present set the stage for us, if you would, Suzanne.
Okay, I think I'm unmuted. This opinion was published for comment after the January 2020 ethics meeting, and then again after the April council meeting. The proposed opinion pertains to negative online reviews posted by former clients and addresses whether lawyers may respond to the former client's negative reviews. The proposed opinion concludes that a lawyer may respond to the negative reviews, but may not include any confidential information in the response. The opinion specifically discusses the self-defense exception to the duty of confidentiality set out in Rule 1.6b6 and concludes that the exception does not apply to negative online reviews. We received several comments to the proposed opinion during the past 2 quarters. I'm going to just summarize those for you. I think every comment we received emphasized the importance of online reviews to a lawyer's practice. Several lawyers commented that they feel they should be able to respond more fully to the negative reviews and include confidential information in their responses because these reviews are so important to their practice. One lawyer commented that he feels a client waives confidentiality as to the content of the posted reviews, which he feels should allow him to respond to any specific statement in the review. Another lawyer believes the opinion as written violates lawyers' freedom of speech. One lawyer pointed out that non-lawyer businesses that, for example, provide legal documents are not restrained by the rules of professional conduct and are allowed to respond to negative online reviews, and this leads to an unlevel playing field. And several lawyers requested that the opinion contain more inquiries addressing other specific scenarios, such as when a client gets their friends or family to post false reviews, when individuals who seek representation but are denied representation post negative reviews, when the lawyer believes a negative review amounts to libel. And another lawyer suggested that the opinion should discuss advance waivers of confidentiality in the event a client posts a comment the lawyer feels she needs to rebut. We did receive one comment that generally agreed with the opinion as written. She agrees that lawyers should be restrained and limited in their online responses. And I will note that we received another comment late yesterday, but it basically reiterates some of the comments that I've already set out here for you.
Okay. Thank you, Suzanne. And then Gina, this is your subcommittee, please.
There you go.
Am I unmuted?
Yes.
Sorry, you'd think I'd have more experience by now and be able to do this. I don't have anything to add to what Suzanne said. I mean, it's just, we've all talked about this before. We have restraints in our abilities to defend ourselves based on our other ethical obligations. So there's nothing new in there.
And is it your, do you have a motion that this be returned to subcommittee for further study, or this has already been published, right? So it would go to council for adoption. So what are those two motions?
That's correct. Suzanne, I believe you just said that the only new response you've gotten is in favor of it. Is that correct?
No, that's not correct. We had several comments that asked for additions to the opinion, and it would be my suggestion that it go back to subcommittee so that we could perhaps add a few more specific inquiries.
So the ones you just went through are new?
Yes.
Okay, never mind. My apologies. I misunderstood. Absolutely go back. We have more work to do.
Okay, so the motion is for the matter to be returned to subcommittee for additional work. Is there a second to that?
This is Ted. I would second that. I'm on that subcommittee.
Great. Thank you, Ted. Do you have anything, now the matter's open for discussion, Ted, do you have anything else to add, or?
No, I'm in agreement. I'm not sure that ultimately anything I've read in the comments are, changes, but I think we ought to look at it and talk about it.
Okay. And Amy, do you have anything to add to that? You're the other member of that subcommittee.
I would add that I continue to be concerned about proportional and restrained response, that particular language. And I think perhaps what Suzanne has said and the inquiries we've gotten to be more specific with more specific examples, we might be able to clear that up a little bit. So I agree sending it back to subcommittee.
Okay, thank you. Are there, now from the committee at whole or from others, are there questions or comments? All right, then in that case, I think if I don't see anything, in that case, we're ready to vote. All in favor of the motion, which is to return the matter to subcommittee, please vote. Please vote yes or no on that motion.
All right, David, I believe that's once again unanimous, 25 yeses, 26 yeses and 0 nos.
Okay, thank you. That will be sent back to subcommittee for a report back in October. Now we're on to the new inquiries. Inquiry of Allen, not related to me, so no need for me to recuse myself. Lawyer as witness solo practice. Suzanne, this is your matter.
Yes, this is not exactly a new inquiry. This was presented to you at the January meeting in the form of an EA, which would be an unpublished opinion The committee in January approved the content of the EA and requested that the EA be converted to a formal ethics opinion in order to provide guidance to the full bar. The opinion addresses the issue of whether a lawyer who is a sole practitioner may represent his own law firm in litigation, given that the lawyer will be a necessary witness. The opinion concludes that the lawyer is not prohibited by Rule 3.7 from handling the representation. The opinion goes on to state that it is ultimately within the trial court's discretion to determine whether disqualification is appropriate based on the specific circumstances of the litigation. The opinion also concludes that if the court were to find that the lawyer is disqualified from representing his law firm at trial, this finding would not prohibit the lawyer from representing the law firm in a motion for summary judgment.
Okay. Ted, this is your subcommittee. Do you have a motion for us?
Yeah, man. I thought that the opinion was well written and I was in complete agreement. So I would move for publication.
Okay, thank you. Is there a second for that? Jerry?
Second.
Thank you. And Jerry, you're on that subcommittee as well. Do you have anything to add on there? I'll teach you to raise your hand. All right, Lamar, do you have anything to add? All right, all those, I don't see anything, any other hands raised? All those, then please vote on the referral of this matter to the council for publication.
And once again, we're at a 26 yeses and 0 no's.
All right. The next matter is, looks like it comes to us from an out-of-stater. This is Senator Cory Booker is making some inquiry. No, I'm sorry, that's Cory Busker. Use of machine learning in law practice. This, Brian, is yours.
Yeah. So you know, as our inquiries continue to focus on the different developments with technology, Suzanne and Nicole decided they did not want to touch this artificial intelligence inquiry and instead leave that to me. So I thank them for that. But on the right after we got done with Bitcoin, suddenly we got an inquiry about artificial intelligence and how a lawyer can incorporate artificial intelligence and machine learning processes into their practice. What sort of professional responsibilities exist for the lawyer in utilizing this machine learning, you know, supervisory things, how much can you rely on results, confidentiality issues. There's a lot of other things that can be brought up, at least on the surface, but frankly, this, similar to Bitcoin and the question about virtual currency, is a topic that I guess it can be very broad and very deep and very complex. I have not drafted an opinion because I feel this topic needs to be understood before we figure out just what the scope of the question should be. But then on top of that, exactly what the outcome of any inquiry should be as well. So, so my proposal is to send this to subcommittee to have a similar process to what we saw with virtual currency, where we engage in some discussion and some education on the matter, particularly with the assistance of some experts on the topic within our state. And that will help us narrow our focus to understand just what the inquiry should answer, and of course, what the outcome should be. So again, my recommendation is that this simply be sent to subcommittee for further study.
The committee will please note that we punished Mr. Edwards by making him take charge of the Bitcoin matter. So we decided to punish Mr. Savage by making him take charge of artificial intelligence because he has no native intelligence. Warren.
I too was on the Bitcoin committee and pulled out my tinfoil hat and am ready to dig in and move that we send this to subcommittee.
All right. Since Warren is fully protected now with his tinfoil hat on, is there a second for sending Warren to Dorothea Dix and sending this matter to subcommittee?
It's right down the street.
Did we get a second on that? I'm sure somebody seconded that.
I'll second it.
All right, thank you, Kevin. And other questions or comments from folks about the motion to send this to subcommittee?
See, Tom Anglem has his hand up.
All right, Tom.
Oh, you're muted right
Just
now, Tom.
gonna, I was just going to second it. I'm good. Thank you.
Okay.
All right. Thank you. Then all in favor of sending the matter, I'm sorry, please vote to on whether or not to send the matter to subcommittee.
All right, I believe voting is concluded. This is unanimous once again, 25 yeses and 0 nos.
Thank you. The next is investment in litigation financing. New increase. Suzanne, this is yours.
Yes, I think I'm still unmuted. Can y'all
Yes.
hear me? Okay. We received an inquiry, excuse me, from a lawyer asking whether he could invest in a particular litigation financing fund. The fund advances money to plaintiffs or law firms in commercial litigation in exchange for a share of any recovery. The fund's advance might be used to pay litigation expenses or attorney fees. The fund makes numerous investments and the profits are passed through to the investors pro rata. The lawyer would not refer clients to the fund and would have no control over the fund's investments. The lawyer states that it is possible that the fund would advance money to lawyer's firm to support litigation that the firm is handling on behalf of a plaintiff or to the plaintiff directly. It is also possible that the fund would advance money to a plaintiff or law firm that is an opposing party of the lawyer's law firm. The issue is whether the lawyer may invest in the fund given these possible scenarios. The opinion concludes that the lawyer may not invest in the fund based on 3 conflict of interest rules. The first is Rule 1.7, which addresses conflicts of interest with current clients. Rule 1.7 prohibits a lawyer from representing a client if the representation may be materially limited by a personal interest of the lawyer. The goal of the fund and the lawyer presumably is to make a profit. This goal may not align with the best interests of a particular client. Therefore, the opinion concludes that the lawyer has a conflict because the lawyer's interest in making a profit has the potential to compromise the lawyer's professional responsibilities to his clients. The second rule is Rule 1.8E. That rule prohibits a lawyer from providing a client with financial assistance except for court costs and expenses. The facts provided in the inquiry indicate that the funds advanced may be used to pay attorney's fees. The opinion states that the advancement of attorney's fees is not an advancement of court costs or expenses and is a prohibited advancement of financial assistance under Rule 1.8E. The final rule is Rule 1.8I. That rule prohibits a lawyer from acquiring a proprietary interest in the subject matter of litigation the lawyer is conducting for a client. The opinion provides that by providing money to lawyers' clients in exchange for a share of any recovery, the fund and the lawyer as an investor in the fund would acquire a prohibited proprietary interest in the client's claim. The opinion then points out that there are no informed consent exceptions to either Rule 1.8E or 1.8I. The opinion also points out that pursuant to 1.8J, the lawyer's conflicts of interest would be imputed to all the members of his law firm. The opinion concludes that because there is a possibility that the fund would advance money to either the lawyer's firm, to a plaintiff represented by the lawyer's firm, or to a plaintiff or law firm that is an opposing party of the lawyer's law firm, the lawyer may not invest in the fund.
Okay. And Steve, This is your name is associated with this. Do you have a motion for us, Steve?
I gave this some study and I don't see any flaws in it. I looked over the New York opinion. I'm not sure it really requires any further study. I think it's quite clear that there are conflicts of interest here, especially in the case where you may even be on the opposite side of your client who's seeking this litigation funding. It's just quite clear to me that these are conflicts of interest. The only thing that caused me pause is suppose you're invested with Fidelity or some huge, and maybe there's some overall exception in our rules to this, to where your interest is so de minimis you don't even know about it, and it's in a mutual fund that may have an interest in litigation funding for profit. That would be my only concern. So I think I would move that we adopt the rule as Suzanne drafted it, and I think it's good work.
Okay, thank you. Is there a second to send the matter on for publication? Stuart?
I second it. I agree.
Okay, thank you. Let's see, who is it? Alan, are you on that committee? I think, yes. Alan, do you have anything to add on that? No, you're not. This is not really when I say committee, your name's associated with this. Alan, do you have anything to add to this?
I don't. I agree completely. I think it.
Okay.
Publish it.
I'm sorry. I'm sorry, Alan. I talked over you. I'm sorry.
I said I think it should be published for comment.
Okay, thank you. Other questions, comments from the committee? All right, the motion is to send the matter to council for publication as drafted. All in favor, please, folks, please vote with using your voting buttons, either aye or nay.
All right, we are at 26 yeses and 0 nos.
Okay, great. Thank you, folks. The next matter is inquiry of grievance, lawyer responsibility in avoiding fraudulent attempts to obtain entrusted client funds. Brian, this is you.
Yes. So as you can see in your materials, Barry McNeil with the Office of Counsel sent really 2 inquiries. The second inquiry is addressed on the addendum in item number 7. So we'll get to that later. But the first inquiry that he had submitted, this is from the Grievance Committee, or a request from the Grievance Committee to address a lawyer's responsibility to avoid wire fraud. As perhaps the members of this committee, whether you're through the committee, through your involvement at the state bar, or maybe your professional lives know, there is a pretty significant risk of wire fraud when it comes to real property transactions. Lawyers have been dealing with this for some time, and I know the Grievance Committee has been dealing with this for some time. We do have a number of cases open kind of on a regular basis where just as the way that, as you can see in the fact scenario, how this plays out, that essentially when somebody's engaged in a real property transaction and there's a need for the buyer to wire funds over to the lawyer to complete the transaction, oftentimes whether you're talking about a hacker that somehow gets into someone's email account, or just somebody that simply detects and figures out who is the person, who are the parties involved, and they essentially they mask themselves. They make them look like they are the lawyer, and they send fraudulent instructions to the client by email saying, I previously told you to send the money to this account. I want you to send it to this account now. And the client, following what he or she believes is the lawyer's instructions, ends up doing that. But of course, by doing so, wires the money to a different account, and the client learns that their money was essentially sent to the wrong place when they get to closing. So there's always been this question that's been pending of what exactly is a lawyer's responsibility in addressing the very present and real threat of wire fraud in a real estate closing. So this opinion goes through that analysis, and this opinion ultimately says that a lawyer has a duty of both competency and communication. A lawyer has a duty of competency to be aware of this this potential risk that's out there. Not really potential risk, the very real risk that's out there. And that's been noted in the opinion goes through and notes the different warnings that have been published, both by the state bar as well as by the general media, that this is not a terribly unique issue. It's been talked about a lot, but a lawyer does have a responsibility to be aware of this and ultimately to communicate the risks that are associated with wiring funds in connection with a real property transaction. And as the facts go through, the facts essentially set up a scenario where, or ask the question where lawyer has provided that information, has provided client with this warning by letter. Has lawyer fulfilled his or her obligations? And the answer is yes, that essentially as long as lawyer has, again, educated him or herself and communicated the risk to the client, that lawyers fulfilled his or her professional obligations. But of course, if lawyer does not provide that warning and does not send a letter or perhaps an email, but basically does not communicate this potential risk, given the frequency and the very real threat that exists out there, that a lawyer would fail to comply with the rules of professional conduct by not providing that warning to clients about the risks associated with wiring funds in connection with a real property transaction. The opinion also speaks to whether or not an email is sufficient, or if you can include generic language at the bottom of your email, if that's sufficient as opposed to a specific letter. And the opinion does say that essentially the medium isn't really the big question. The question is whether you have provided the language, and even if you're including it as generic information that's included in all of your emails, to point out to the client, you need to read this language that is contained at the bottom of this email. To be sure that you're aware of the risks that are associated with wire fraud or wire transactions. And lastly, there was a question posed as to whether the lawyer has a duty to report the theft. If wire fraud does occur and the client loses money due to this scenario playing out, does the lawyer have a duty under the rules of professional conduct to report that theft to Trust Account Compliance Council under Rule 1.15-2P? And the answer to that inquiry was no, that essentially because these funds have never been received by the attorney, that they are not funds that have been misappropriated. They are not safeguarded and trusted funds that have been misappropriated. And therefore, that duty to report has not been triggered. However, the opinion does say that lawyers are encouraged to report to the state bar when this occurs, so we can keep track of the existence of these different schemes, particularly when a particular scheme becomes prevalent at any given time. That will enable the state bar to alert lawyers to a particular scheme that's being run amongst the public in different transactions in North Carolina. So ultimately, that is the conclusion of the opinion. This is one that I feel it could go either way as far as recommending to subcommittee or recommending for publication, because there are, I think, a lot of things that are involved here, particularly with regards to practitioners and the practicality of this and what exactly constitutes reasonable safeguards. And I will just note that the opinion does not go into specifics because, as we've said in other opinions, starting to generate lists of specific things that should be done that are considered reasonable safeguards really can be flawed. And that's flawed because, one, the schemes change constantly. They're always evolving. And so it's hard to kind of nail down any particular thing that would be a reasonable safeguard. It'll probably be different within a couple of months. But two, that sometimes listing those specifics creates a false sense of security. And lawyers instead should just be, aware of their overall obligations to be mindful of this and to really adapt their reasonable safeguards as the circumstances warrant. So ultimately, it would be my recommendation that I think a subcommittee would be able to study this and discuss it. I think that'd be a good place to start, but nevertheless, it'll be interesting to hear the committee's response.
Thank you, Brian. Sally, this is your name is on this one.
I don't think Sally is on. Oh wait, no, she is here. I'm sorry. Sally? Sally, we cannot hear you.
She may have stepped away from her computer, Brian.
Yeah.
And I know, I think John has left. I got an email from John.
She's unmuted now. She just unmuted.
Okay, sorry. I don't know what I'm doing. I agree with everything that was said about this, and there are a million different things that could come out of this. And I don't know how you keep ahead of the crooks out there. So I have experience in my office with the partners who handle a lot of real estate transactions, and they do those letters at the beginning with the engagement letter so that everybody knows from every end that this is possibility and that you have to call the office directly and that kind of thing. So I think it's exactly right.
Sally, would you move for publication, or would you move to send it back to subcommittee?
I would, well, I think it's always going to be a moving target. So I guess I would move that it go to publication.
Okay. And I got an email, I got a message from John Webster. He had to step out to a hearing. And so Ripley, do you have a second, or do you have comments on this?
Second that. I don't have any additional comments.
Okay. Warren, I see your hand up.
I'd like for this to go to subcommittee for the reason that this is often in the context of litigation, and I feel like we are crossing a line here potentially that I'd like to be discussed. I don't know, at least discussed and fleshed out, that frequently the hack comes in the through a real estate agent, through the buyer themselves. You were talking about money that never even gets to the attorney's trust account. There's so many moving parts. I feel like we are essentially potentially setting a standard of care as opposed to opining on ethics. And I would like this to be discussed more fully with input from the real estate bar and others as to the implications of the opinion.
Okay, thank you, Warren. Evan?
Thank you, David. I agree with Warren. You know, the committee that's still in search of a name and the cybersecurity committee had a joint meeting earlier this month, and we got a lot done. And I think even as Sally said, there's a lot of moving parts here. And I think it needs to be studied more fully. And also, I think it needs to coordinate a little bit with the PMBR and cybersecurity work. So I would vote against it being sent for publication and make an alternative motion that we send it to subcommittee.
Okay, if you
If I can, I'll withdraw my motion and second Evan's motion.
Okay, and Ripley, I guess we need to hear from Ripley. You okay on that, Ripley?
I'm happy to third that or whatever the appropriate procedural machinations are.
Thank you. It's you know, I have my Robert's rules somewhere, but I think the easiest thing is to say that Sally has modified her motion to send the matter to subcommittee, and that Ripley has seconded that, and we'll just take Mr. Rawls's comments as comments, and we'll vote on that. So all in, everyone, please vote on whether to send the matter to subcommittee. Vote aye, vote yay or nay, please.
All right, and we are at unanimous 24 yeses and 0 no's.
Thank you. The next matter is inquiry of con. This is confidentiality. No, I'm sorry, I skipped one. This is Nicole on the lawyer possession of contraband during representation, inquiry of grievance.
Yes, we got this from the Grievance Committee regarding whether or not a lawyer can possess pictures or images of children engaged in sexual activity. In the first inquiry, the lawyer represents mother in a custody action. The client has reviewed her child's phone and discovered that there are pictures of the minor child engaging in sexual activity, and that this occurred while the child was in the custody of the defendant father. The client wants the lawyer to use the pictures as evidence against the father in the custody action. The lawyer hasn't taken possession of the pictures, but the question is, may he do so? The opinion provides that images portraying children engaged in sexual activity is contraband, and that the possession of contraband is illegal and prohibited by state and federal law. We also have an ethics opinion that says that a lawyer cannot possess a client's contraband. The opinion further provides that the lawyer has a duty to provide competent and diligent representation, and therefore, if the lawyer determines that the picture is necessary and would be helpful to the client's matter, that the lawyer should seek a court order allowing the lawyer to take possession for the sole purpose of presenting the photographs as evidence and to protect against the dissemination of the photograph outside the litigation process. The order should include or shall include the mechanism by which the lawyer will copy the pictures from the minor's phone. Inquiry number 2, the question is, what duty does the lawyer have to protect the minor's interest? And the opinion concludes that if a lawyer is permitted to take possession of the pictures, no duty is owed to protect the interests of the child because the child is not the client. Inquiry number 3 includes the same fact pattern as inquiry number 1, except that the client, without any notice to the lawyer, sends an email with attaching the pictures of the minor child engaged in sexual activity and sends that to the lawyer. The opinion provides that because the picture is contraband and it is illegal to possess, the lawyer cannot take possession unless he first obtains a court order as outlined in opinion number 1. The opinion further provides that the lawyer should advise the client to delete the email and that the lawyer should also delete the email. However, the lawyer must be mindful of his obligations to not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value, and that is prescribed in Rule 3.4. The lawyer should also examine the law on preservation of information, spoliation of evidence, and obstruction of justice to determine whether or not deleting the email would be a violation of the law. And the opinion references 2014 Formal Ethics Opinion 5. I have to say that when I first got this inquiry, I thought it would be easy because I was for sure positive there's an exception in the statute that allows prosecutors or lawyers who are defending a client in the criminal context that they could possess this. And there's no such exception that I could find. I talked to a prosecutor, I talked to 2 criminal defense lawyers who confirmed that they are not aware of any exception in the statute, but they all said that it is not likely that a prosecutor would ever prosecute a lawyer for possessing pictures in the context of representing a client. With all that said, I still have some, would like to hear more comment from other prosecutors, criminal defense lawyers, domestic lawyers, and it is my recommendation that this go to subcommittee.
Okay. Thank you, Nicole. This will be, Takia, this is your matter. Do you have a motion for us or comment?
Oh, we can't hear you. It says you're unmuted, but we cannot hear you for some reason.
Oh, okay.
Oh, no, we can hear you. We're good.
Yeah, I would make a motion to move this to subcommittee. I think it needs to be discussed a little bit more. Things need to be fleshed out.
Okay, thank you. And let's see, Tom or Butch, either one of y'all, we need a second, and then any comment from either Tom or Butch.
I'll second that motion.
Okay.
I'll second that motion.
Great, thank you.
As far as comments, I think there are some other issues that need to be discussed. including the mandatory reporting laws where everybody is under obligation to report to DSS any potential abuse, neglect, dependency issues. So.
Thank you, Tom. Any further comments from anybody? Any other hands raised?
Yeah,
I saw some earlier.
Yeah, Missy has her hand up and Ripley then. So we'll go with Missy first.
I'm to volunteer to be on the subcommittee. I recently attended a national CLE that addressed this issue, so I'd like to participate.
Super, thank you. And then Ripley? I'm sorry, anything else, Missy? I'm sorry. Okay, okay, thank you. Ripley?
I'm also glad to serve on the subcommittee and agree that it should go to committee. There are a couple of additional conversation points. Receipt of child pornography under federal law is a 5-year mandatory minimum sentence, and there is no exception for the attorney-client relationship or anything like that. Most prosecutors' offices, whether state or federal in North Carolina, do not allow the defense attorney to have copies of the discovery when it involves images of children. There are also issues involving restitution that is paid to victims under federal law who are represented in images that are disseminated. The restitution provisions of federal law also could be involved here. And there's an additional technology awareness. The technology involved in a lot of the way these things are disseminated or copied is very complicated, in my experience from the U.S. Attorney's Office. So I think talking about all that and the other issues that have already been discussed would be helpful to this.
Great, thank you. Other comments? I don't see any other hands raised.
None.
All right, please vote then to sending this matter to subcommittee. Missy, do you have a hand up? I'm sorry.
I think it was a vote of yes.
Okay.
I need to take my man down. Sorry. Oh, wait, yeah. Sorry.
Okay.
Well, we have a unanimous vote of approval here, 22-0.
Okay, great. Thank you. Next matter is inquiry of COM. This is confidentiality of public information. Suzanne, this is yours.
Suzanne, I had muted you. You need to unmute yourself.
Peter's exercising his authority to just mute people whenever he wants. So.
Anyway, this is a really interesting inquiry that I think is going to get a lot of discussion. I'm sure that this is going to go to a subcommittee, so I will be brief. It deals with confidentiality and information in public records. A lawyer who worked on a high-profile case that received a lot of publicity was asked at the conclusion of the case to participate in various podcasts and CLEs. The lawyer planned to limit his comments to information and events contained in the public record or occurring in public hearings. Although the lawyer did not feel like he needed his client's consent to participate in these programs, he went ahead and asked the client for consent. The client did not consent. The client specifically asked the lawyer not to discuss his case. Despite his client's response, the lawyer feels he should still be allowed to participate in the podcasts and CLEs. The lawyer believes that a prohibition on former counsel discussing publicly disclosed aspects of a client's case would not serve the needs of the public to be informed about current legal trends. He also feels that such a prohibition would curtail his First Amendment rights. The question posed in the inquiry is whether the lawyer may ignore his client's request and go ahead and speak publicly about the client's case. The opinion concludes that the lawyer's duty of confidentiality prohibits him from publicly discussing the client's case unless he gets his client's consent. The opinion points out that Rule 1.6 requires a lawyer to keep confidential any information acquired during the professional relationship with the client or any information relating to the representation. Because public records regarding the case are information relating to the representation, they are protected by Rule 1.6, and there is no exception for public records in that rule. The opinion goes on to state that the duty to protect information relating to the representation, including public records, is extended beyond the conclusion of the representation by Rule 1.9c. That rule provides that a lawyer who formerly represented a client may not reveal information relating to the representation. The opinion cites a 2018 ABA formal opinion, as well as several state ethics opinions, which conclude that all information relating to a client's representation is protected information, even if information has been in the news, is included in court orders, or was provided in public judicial proceedings. The opinion does note that there is a case out of Virginia where the court rejected the Virginia bar's conclusion that Rule 1.6 prohibited a lawyer from posting information from a client's trial on his blog. The Virginia court found that the prohibition did infringe on the lawyer's right to freedom of speech.
Thank you, Suzanne. It's a fascinating inquiry, and if you read the materials that are in there, so it really is a fascinating sort of topic to get into. Don't know why it was really assigned initially to Evan, given its fascinating nature. But we'll move to Mr. Rawls. Do you have a motion on this, Evan?
I do, Mr. Chairman. Motion that we send this to subcommittee, and I'll make a few comments after a second.
All right. Is there a second from this?
I'll second.
Thank you. And while we have you up, Judge Pittman, do you have anything to add?
No, should be fun to look at.
Thank you. At the risk of going back, Mr. Rawls, you said you had some additional comments?
I do, and I'll be very brief. This is kind of like who knew that the net spread this far, that a lawyer cannot reveal any information from whatever source, even the news, public hearings, transcripts, court orders, can't even use hypotheticals in certain situations. You're right, the materials attached to this inquiry of Con are fascinating. And it really does drill down into current clients, former clients, prospective clients, pending cases, concluding cases, distinguishing embarrassing and detrimental information as opposed to other types of information. It also talks about First Amendment issues, which I think are front and center, as Con points out in his inquiry. This is going to be an interesting and fascinating subcommittee. And I think in one of Suzanne's emails, she said it might be time to review exactly the stretch of 1.6. And I agree with that. I think we need to look at it and make some changes.
Warren?
I was just going to note that several CLE providers will no longer have any substantive thing about it. CLEs.
That's the truth.
You can still do it if you get consent, Warren.
Yeah. But I think I
didn't get consent.
And I'll just add that, this inquiry, when it came in, just what you said, Evan, it really kind of made us think, my goodness, do we need to examine the rules? Because I think the rules they set the parameters there. And I was frankly expecting to find more in terms of ethics opinions or court cases that expanded, that basically said, no, public information is permissible, but it was quite the opposite. There's a great deal of other jurisdictions that have issued opinions, including the ABA, that have said, and lawyers that have been disciplined because the rules are what they are. Only the Virginia court, I think there may have been one other case that I can't recall off the top of my head, but the Virginia court is the clearest example of a Supreme Court opinion articulating that the harm that's supposed to be protected or the harm that we're addressing in 1.6 is not really furthered, or is not really guarded against, I should say, by this rule to prohibit public information being discussed by the lawyer. So I think there's some very interesting aspects here. I'll be very curious to hear what the subcommittee discussion entails.
All right, this is to be sent to subcommittee. That's the motion. Please vote using your buttons.
And we have, it looks like, once again, unanimous. We're at 24 yeses and 0 nos.
All right. The last matter under new inquiries is inquiry of grievance from the second one from Barry McNeil, responsibility in identifying and avoiding counterfeit checks. Brian, I think this is you.
Yeah, so this matter is on your addendum. Just so we're all clear, if you're on page 52, or starts on page 52 of the addendum PDF. So this inquiry, again, it was submitted by the Grievance Committee via Barry McNeil. And this inquiry asks about a lawyer's professional responsibility with regards to counterfeit checks, particularly the process of identifying and avoiding those counterfeit checks. The scenario that was presented, and this is a scenario that has been presented to the Grievance Committee, the Office of Counsel, once again, and perhaps sadly, continues to get complaints or just otherwise get alerted to the fact that a lawyer has fallen victim to one of these counterfeit check scams. Essentially, the scenario is what you all likely have heard about because this has been discussed in a number of different ways, as the opinion points out. But essentially, a client just kind of contacts a lawyer out of the blue and says, "I'd like your help in collecting some debt." And so client and lawyer engage in that negotiation. Lawyer is retained by client, sends one introductory letter, and suddenly the third party or the purported defendant is very quick to provide a cashier's check, saying, I'm ready to settle this matter. I don't want to go through anything further. Essentially let's just get this over with. And I will send a cashier's check right away. The cashier's check is often drawn on a bank that's out of this country. When the lawyer accepts the check, then the lawyer will essentially deposit the check and get an instruction from the client, please disperse this promptly. You can take a certain percentage, 20% of the amount deposited as your fee, for the minimal work that you've done. But take 20% off, or take 20% of it, that's your fee, and then send the rest of it to this bank account. And this bank account, like in the scenario, describes one that's essentially in another state and another one that's in another country. And ultimately, the cashier's check is discovered to be fraudulent. It bounces. The money does not go into the trust account, which means that the disbursement that the lawyer made upon depositing the check, because it's a cashier's check, then the lawyer felt comfortable and authorized to disperse on provisional credit. But of course, that credit never actually goes into the account, meaning that lawyer has dispersed other client funds to himself as well as to this purported client, which ends up being just as part of the scam. So the question that was posed in this inquiry is, well, did lawyer violate the rules of professional conduct by falling victim to this scam? And the answer was yes. That essentially a misappropriation did occur, a technical misappropriation did occur, because other client funds were dispersed without those clients' authorization. They were dispersed to someone other than the benefit, or for the benefit of the client. And ultimately, that is a technical misappropriation under rules 1.152A, K, and N. But then we have some issues as far as what should lawyer have done. And similar to the other inquiry, we have competency issues. And in this one, we have diligence issues. So the competency aspect, of course, similar to the other inquiry, that lawyers are instructed to have that preparation, to maintain competence in whatever matter they're undertaking. But the comments to the rules specifically reference that to maintain the requisite skill and knowledge that's needed for competent practice, a lawyer is supposed to keep abreast of changes in the law and its practice. And so the opinion goes on to discuss all the different publications that exist out there regarding counterfeit checks. I mean, there are bar associations from across the country, including our own, have published a number of different notices, alerts, articles discussing these different scams. And certainly state and federal agencies have advised the public routinely about these ongoing scam efforts. And essentially, it's the question, I think, really that's kind of underlying this opinion is, have we reached a point in practice and just in how, kind of in reality, where lawyers should not be falling for this anymore, particularly when they put other people's money at risk? Instead, they should have been competent to recognize it, and even if they had a suspicion, they should at least recognize this, whatever suspicious circumstance exists, and take the extra step to investigate, to authenticate that this truly is a legitimate cashier's check. Now, that brings up a whole bunch of practical reality questions too. Can you really contact the bank in Poland or wherever it is and get a legitimate answer and a prompt answer at that to determine that this cashier's check is in fact real? So I think there's a lot of stuff that needs to be discussed here. Again, the opinion does say that it is a violation of the rules to basically fall victim and disperse other people's money when you don't have their authorization as a result of this scam. Does the lawyer have a duty to replace the funds? The opinion says yes. Does the lawyer have a duty to report the theft or the misappropriation, I should say, to the trust account compliance officer? And the opinion says yes, because at this point you have inappropriately dispersed entrusted funds that belong to another person. So ultimately, again, there are a lot of things to discuss. I would recommend that this one go to subcommittee to have that discussion.
All right, Brandy, this is you.
I was glad to read the opinion, and I think it makes plenty of sense. I understand that we do need to move it to subcommittee, and I'm going to make that motion that we move it to our subcommittee. I just would say, just for Brian's edification when he schedules the meeting, don't make sure you check with me to not interfere with an upcoming meeting I have with the Minister of the Interior from the Netherlands. I understand I've won the Dutch lottery, and I don't want to get in the way of that. So anyway, well, that's my motion.
Duly noted, Brandy.
Well, if you don't attend the October meeting, we'll know you're in the Antilles with your lottery proceeds. Is there a second for that?
I see Stuart has her hand up. I don't know if she's trying to second or she has a comment.
I have both. I'll second it to go to subcommittee. In reading the opinion, the question that I had is, how long did the attorney, I don't think these facts are in the opinion as written, but how long did the attorney wait before dispersing? What are the rules? Did he follow the rules that the state bar sets forth in terms of waiting long enough to see if the funds are actually good funds? And I think those issues need to be fleshed out. I'm aware of this scam, not specifically with regard to cashier's checks, but the way I've always heard it is that the attorneys have disbursed before the requisite period has passed. And I think that's clearly a violation here. I had that question. And so I'd like to be on the subcommittee if possible.
Thank you, Stuart.
England.
Yeah, I had just a comment. I think Brandy's a great person to be on this committee. I'm not really interested in being on it, but two observations. Number one, I can't tell you how many times I've been involved in prosecutions where you get these checks from foreign countries. And I certainly believe that attorneys can be gullible enough to do this in some respects. But if the initial client is a fraudulent client, does the bar still, and I know the other rules that we're talking about are relevant and applicable, but are we really going to punish an attorney for being, if they exercise their due diligence and are not negligence, are we going to be punishing an attorney for being duped under these circumstances? Because they really are the victim when that first person who comes in and represents themselves as a client isn't a client. So, are we going to redefine what a client means in that context under these circumstances, under the rules and the opinions? I'll shut up and mute myself.
I think the real problem is when it's the other people who have money in the trust account. They're the ones that are getting bad stick.
Okay, that's the, are there other comments or questions?
Eben?
Yeah, I would say I had this happen at my law firm a few years ago. I had an associate that was handling a situation sort of unsupervised. And this associate came to me, thankfully, after she received a $354,000 cashier's check. And I, drilled down into it, and I decided absolutely it was fraud. I called the FBI. I still have that cashier's check in my office for $354,000. But it's also made me aware that, once again, the responsibilities of lawyers to train their staff and to supervise diligently, especially with monetary matters. The other thing that comes up that's really big in banking and financial industries now is KYC, know your customer. And this is a situation where I think lawyers have a duty to know their customers and know their clients, and do some real due diligence into financial situations like this. So I think it should cover staff and also KYC.
Okay, thanks. No more comments, then the motion is to send the matter to subcommittee. Please register your vote using your tabs.
We are at 21 yeses and 0 nos.
All right, thank you. And the last matter that we have is the ethics advisory. This was a matter that was Brian and I discussed during the some time ago, right? As COVID was really taking hold, to issue some guidance, and I thought Brian crafted a good letter for us that was an EA that we sent out in your. We'd like to have this now, have the committee validate the work that was done while we were on recess. Brian, can you walk us through, please?
Sure. So as David just said, this was brought up as a result of the initial shutdown, really in March, due to COVID-19. We received a number of inquiries, particularly with regards to real estate transactions, whether or not a lawyer could instruct a staff member, or the lawyer, him or herself, could conduct a remote notary session, essentially notarize stuff by video conference and things of that nature, as well as the question of, essentially what is a lawyer's responsibility if there is, if there's some sort of change in the law that would allow lawyers to disperse funds or basically conduct closings before, maybe what the lawyer's responsibility or what the lawyer's abilities are before recording, because of course the Register of Deeds offices were then closed, or some of them were closed, and just this question of, well, what am I supposed to do with this money? Seller wants to get their proceeds from a particular real property transaction, and I usually cannot, and I'm statutorily prohibited from dispersing until the deed is actually recorded. So of course we noted in the opinion, I guess as to the first one, that essentially that is a statutory matter, and that a lawyer is bound by the requirements and restrictions of the law. And to the second matter, kind of a similar response that, essentially the Good Fund Settlement Act does require a lawyer to only disperse funds after the documents that reflect the property transaction have been recorded in the Office of the Register of Deeds. So, but that being said, we were also aware that there was some movement at the General Assembly, that people were proposing different amendments for this sort of disaster period. And so the opinion went on to say that, if anything were to change that would allow a lawyer to comply with their statutory obligations in a different way, these are the things that you need to consider. And particularly, with regards to the first one, yes, it was just more of The notary issue is just simply the restrictions are imposed by statute. If those things are lifted, then a lawyer is permitted to move forward. But just to be mindful of the fact that violating those statutory provisions is actually deemed a crime in North Carolina. And so lawyers need to be very cautious of that and be just mindful of that. With regards to the second one in the Good Fund Settlement Act, the opinion goes on to say that, if essentially the statutory restrictions are lifted and lawyers are allowed to disperse prior to recording, that there are a number of issues to consider, particularly with regards to their obligations under 1.7 and 1.4 to fully inform their clients and the different parties to whom they owe responsibilities of the potential risks. And we listed just kind of a handful of those risks, particularly, thinking about things like, okay, well, if somebody, if you end up transferring this property, somebody acquires property, but the money, I guess the deed has not been recorded, are you advising your client that, you may have possession of the property even though you don't technically own it, you don't have the formal deed recorded, who is going to be liable if at some point damage occurs to the property? Before you move in, a tornado comes through and damages things, where exactly is that? And that's just the lawyer's responsibility to be mindful of these different conflicts that could arise and the different risks that were associated with proceeding in this manner, namely of transferring property without legally recording the deed. Since we've issued this opinion, amendments have been made to the statute that allow lawyers to go forward with this. And so I think our opinion is very relevant and it remains up on the website. We have gotten some good feedback from it. I think lawyers have appreciated it. We have sent it out in response to a number of inquiries. So we still think that it's a relevant opinion. We want to keep it on the website, and we would just ask that this committee essentially ratify this ethics advisory.
So this is really here for ratification. We thought it was necessary to get this out as quickly as we could during the crisis. You see it's dated March 27th. So it's up on there, and we would, I'm not sure what the proper procedure is. Would it be to adopt that, just to adopt the ethics opinion?
Yeah, it would be a vote to approve the ethics advisory.
All right. Is there, we would entertain a motion to approve the ethics advisory as you see it in front of you.
Move approval.
Thank you. Is there a second for that? All right. I see some hands going up. Thank you. If now there'll be further discussion. Any questions or comments on the materials that you see in front of you?
I don't see any hands.
All right. All those in favor, please say, or please vote on the acceptance of the EA. This would be EA 2020-2.
I believe that's 23 yeses and 0 nos.
All right, thank you. That will be approved. It will remain up on the website and now with your approval. I think, Brian, is that it for the agenda?
That is the conclusion of our agenda.
Ladies and gentlemen, this has been a very busy day, a very full agenda, and we appreciate your attention to all of the matters that are in front of us. We have a number of matters that will be going before the council tomorrow. And I've made notes on those, but but I'm not going to recount them all because I'm sure I made a mistake, and Brian will keep us honest on that. But thank you very much for your hard work and your attention today, and for working through without our break. I figured we would be cutting it close on time. So with that, unless there are questions or comments.
David, just one quick thing I wanted to share with everybody. This particular screen, so everybody can see it. This is the new email address for those of you on the committee as well as those that are watching at home. If anyone has comments on an ethics opinion that's published over the next quarter, or that wants to offer comments on the preamble proposal or anything else, you can send it to ethicscomments@ncbar.gov. This is a new email address. You will get an automatic reply. We are not going to be replying to every single one of the comments that are submitted, but this is where they will be essentially stored, and they will be, of course, preserved and transmitted to the respective subcommittees and the full committee at the appropriate time. But please do send your comments to ethicscomments@ncbar.gov.
All right, thank you. And by the way, staff has worked remarkably hard while we've been away. We decided not to meet in April. As a result, we had an extremely full agenda today. And also staff was stretched thin to cover all of the matters that came up and dealt with it. As you see from the ethics advisory that we put out to try to give some instruction to the lawyers, have been dealing with a number of issues on top of our normal kind of business that has been COVID related. So a tip of the hat to Brian, Suzanne, and Nicole for their very hard work, and to Lenise also for everything that all of y'all do to facilitate our work. And I thank Peter for not muting me inadvertently during our presentation today. Thank y'all.
You set yourself up, David.
So thank y'all all very much, and we're adjourned. Goodbye.
Thank you.
See you next time. See you tomorrow morning.
Thank you, everybody. Great meeting.